So let's talk about a few things that have come my way, right, in relation to education law, which a lot of people tend to not understand, right, which are not necessarily lawful but tend to happen. And as a result, children end up losing access to education. Let's talk about these. First thing, I often hear from people that, my child has been expelled by a public school on the basis of whatever reason, right? And now my child does not have access to a school. I don't know what to do. Well, first things first, in South Africa, a public school does not have the right to expel a learner. If they have the desire to do so, there's a process that is undertaken. And the person that will give out the word of expulsion is the person we call a head of department of that particular province. So the Department of Education lies with that particular responsibility, right, or authority. So the school cannot do this. Even if they have issued you a letter, you must just know that it's actually unlawful. It should not have happened that way. Another thing, which is the second thing that often I encounter from people, is that they often say, my child is not in school because I have been expelled or they have been removed on the basis that I've not paid a registration fee. Again, first things first, in South Africa, we don't even recognize in terms of law a registration fee. The only type of fee the law recognizes is what we call a school fee. Often schools will invoke a registration fee, which is a discretionary fee, for the purposes of raising their funds, right? So if you cannot pay this fee, if a school has decided to put it in place, they don't have the right to say your child should not get access to education because you have not been able to pay it. In actual fact, even if it was a school fee, which is the recognized type of fee in South Africa, a school still would not be able to say to a child they mustn't come to school on that basis in a public school. The third thing I also often hear, from people who have children in public schools is that they would often say they were issued with a letter from the school that they are removing a child on the basis that they are a slow learner or on the basis that they would cope better at a special school. Well, again, in this particular instance, there is a process that is undertaken before such a decision can be made, right? And so a school cannot just decide to remove your child from the school, especially without access to another school. So even if they've issued you a letter in this regard, you must just know that that particular conduct is unlawful because they cannot just make that decision on their own accord. It is a decision that happens after a certain process, and certain authority or people in authority must give the go-ahead for this. I hope this is helpful.